Let's talk about what happens when a parent who cares primarily for the child or children dies and there's parenting orders in place compared to a situation where there are no parenting orders in place. Importantly, there is no presumption that the child or children will live with the other parent. 65K of our Family Law Act 1975 sets out what happens when a parenting order that deals with whom a child lives with does not make provision in relation to the death of a parent with whom the child lives. So in this circumstance, you've got parenting orders in place. The parenting orders provide for the child or children to live with parent A. Parent A dies, and the parenting orders don't talk about what is to happen in circumstances where parent A dies. This says the surviving parent cannot require the child to live with him or her. The surviving parent or another person, and I'll show you section 65C, who else can make an application seeking parenting orders, may apply for a parenting order that deals with the personal persons with whom the child is to live. Section 65C of our Family Law Act sets out who may apply for a parenting order, and you can see here either or both of the child's parents, so the remaining parent, the child, a grandparent, or any other person concerned with the care, welfare, or development of the child. Paragraph 42 of the 2014 case of Lester and Blackett and Anor explains that the courts have consistently rejected the notion of a presumption in favour of a biological parent. Any parenting matter is to be determined on its own facts and circumstances and in the best interest of the child involved. Go to Google and read section 60cc of our Family Law Act, which sets out how a court decides what is in a child's best interest. Sometimes you might see a situation where the now deceased parent's own parents believe it's in the child or children's best interest to live with them and to spend time with the other parent or no time with the other parent. Again, depends on the factual circumstances of the case. If there are no parenting orders in place, then any person who has standing to seek parenting orders can try to negotiate parenting arrangements. And if they can't reach an agreement, then any person, as set out in Section 65C of the Family Law Act, they can commence court proceedings and they can ask the court to decide the appropriate parenting arrangements moving forward.